Hello everyone, my name is Ethan Lee and my topic is Hygiene Jurisprudence, a study from Constitution, Law, Judgments, and Directions of Taiwan. And these are my table of contents: Introduction, Literature Review, Methodology, Findings, Conclusion and Recommendations, Acknowledgement, and References. First is my introduction that Taiwan has not yet had its own Act of Health. However, the International Covenant on Economic, Social, and Cultural Rights has been incorporated into our domestic law. And in our Constitution, Article 15, that there is a right of existence shall be guaranteed to the people. Article 10, paragraph 5, the state shall promote universal health insurance and research and development of both modern and traditional medicines. And paragraph 12, the Constitution shall specifically safeguard the health and medical care of the Aboriginal and people who live in Penghu, Kinmen, and Matsu areas. In the literature review, I found that the jurisprudence of hygiene is a research gap. In the Ministry of Health and Welfare, I see that the hygiene jurisprudence can be categorized into organization, Division of General Planning, Social Insurance, CDC Food and Drug Administration, Technology Development Unit, etc. The hygiene jurisprudence is based on the Constitution, relevant laws, judgments, and directions with a desktop research, and I use the Law Bank and Law and Regulation database of the Republic of China for keyword search for hygiene and health. That the finding is that the Constitution, such as in Article 108, 110, for the public health, and Article 157 that establish extensive service for sanitation, health protection, and a system of public and medical service. In JY interpretations, such as in 734, it states that the advertisements is not executed as waste in the Waste Disposal Act. In 738, the Taoyuan City, Taipei City and County, they said that the electronic gaming arcades should be 1,000 to 800 meters away from schools, libraries, or hospitals in order to protect people's mental and bodily health. And in 785, it explains how firefighters are civil servants and their health rights. In the institution, we can see such as the Organic Act for Ministry of Health and Welfare, Organic Act of Institution of Labor, and in medical science, the law such as Mental Health Act, Chinese Medicine and Pharmacy Development Act. And in food and drug safety, we can see Cosmetic Hygiene and Safety Act, Act governing food safety and sanitation, or the WHO Framework Convention on Tobacco Control. And in military personnel, civil servants, teachers, laborers, and their location, the sanitation and health related laws. And in the environmental part, there is a industrial pollution that can be sentenced into the criminal code, and there are also the Water Pollution Control Act, Waste Disposal Act, and in the judgment that the body and health damages by a corporation can be adjudicated to other than non-property damage. The directions such as occupation, central health care practices, and districts. My conclusion and recommendation is that I propose the hygiene jurisprudence can be constituted by institution, medical science, food and drug safety, military personnel, civil servants, teachers, laborers, and their locations and environment. The implication is that the Act of Health, as legislated and it should be disinterested in other organizational or institutional restraints so as to safeguard people's health entirely. And the research limitation and future research directions is a complete study of hygiene in the laws, regulations, directions, and cases. And I would like to thank Professor Qinfu Liao for giving me many insightful advice. And these are my references. Thank you.